I want to talk a little bit about the impact of neuroscience research on juvenile justice policy and on the interest in this research in the last decade or so. And I am a really old-fashioned law professor, and I don't have a single picture of the brain or of anything else. So that's just the way it is. But what we're seeing in this trend and this fascination with neuroscience is part of a larger trend in juvenile justice that to some extent is a rejection of, or at least a backing off from, the policies of the 1990s, in which juvenile offenders were labeled as super predators, and states across the country passed laws facilitating adult punishment, prosecution and punishment of juveniles. Well, that period seems to have, or that those attitudes and that kind of distress over juvenile crime has waned to some extent, and what you might describe the current period as almost in some ways a kind of reemergence of the traditional view that juvenile offenders are in some ways fundamentally different from their adult counterparts in ways that ought to affect the way the justice system treats them. But the difference between traditional policy and today is that today the discourse and the policy debate is influenced by developmental science, developmental psychology, and a growing body of neuroscience research, which BJ has described, and some of which is being done by the MacArthur Network. And this research is viewed as being very relevant to juvenile justice policy. And I think going back to the issue that Jeff raised about psychopaths, and that I think is a question that often comes up on these issues, is what does neuroscience really have to add to a body of developmental psychology research that already tells us that adolescents engage in risk-taking behavior, that they're highly subject to peer influence, that they don't look ahead in making decisions, that they're much more emotional. And I think the answer is that research is clearly very important in itself. But I think that by tying the behavioral research to the sort of underlying brain function and structure, that there's a sort of more compelling account of why it is that adolescents act the way they do. So this story that BJ described, that we're learning from the research of this imbalance in sort of the way the adolescent brain develops, with the sort of early development around puberty of emotional centers and activation of those centers, but much slower development of the prefrontal cortex and the connections to the emotion centers that are necessary for self-control. That explains to some extent why it is that adolescents do what they do. And as one scholar described it, it's sort of like starting the motor of a car without a good set of functioning brakes. That's what adolescence is. And so I think it's not surprising that this research has really captured the imagination of the media, certainly, and the public, but also of lawmakers, of courts and legislatures. And BJ mentioned the three Supreme Court cases, the Eighth Amendment cases, that are probably the most famous examples of lawmakers using developmental science in support of a legal conclusion that, in this case, that adolescents, because of their developmental immaturity, are less culpable than their adult counterparts, and that therefore the harsh sentences that might be appropriate for adults are not appropriate for adolescents. So in Roper, the abolition of the juvenile death penalty, in Graham in 2012, the prohibition of life without parole for juveniles for non-homicide offenses, and in Miller, the prohibition of life without parole on a mandatory basis for juvenile offenders, even for homicide. Now, in Roper, the court mentions developmental science, but it doesn't talk about neuroscience, even though some of the amicus briefs made arguments on the basis of neuroscience research, and it was discussed to some extent in the oral arguments, but the court, in its opinion, did not talk about the neuroscience. But in Graham and Miller, the adolescent brain science was really front and center in those two opinions. And the court found life without parole to be an excessive punishment for juveniles under the Eighth Amendment, because they are less culpable, at least in most cases, an excessive punishment. And it emphasized that its conclusion wasn't based on what every parent knows, which is one of the reactions, but on science and social science. So this, this is really the straight story, the court seemed to be saying. And it went on to say in Graham, and repeated in Miller, that developments in psychology and brain science show fundamental differences between juveniles and adult minds. Parts of the brain involved in behavioral control continue to mature through late adolescence. The court also observed that juveniles are more capable of change than are adults, and their actions are less likely to be evidence of irretrievably depraved character. And so, based on the scientific evidence, or at least supported by the scientific evidence, the court found that juveniles are less culpable than adults, and as it said, as the years go by and neurological development occurs, the deficiencies will be reformed. And so these are landmark cases in terms of the importance of this adolescent brain research to courts. And what's happened since Graham and Miller has been, and some of you are probably aware of this, perhaps in your own courts, that there has been a flood of litigation in state and federal courts. So that, for example, after Graham, the long sentences for juveniles have been challenged on the ground that they are effectively life without parole. And so there's a statement in Graham by the court that there has to be some meaningful opportunity to obtain release based on demonstrated maturity, and attorneys for defendants and prisoners have taken the statement to challenge very long term of year sentences that were not life without parole. So that in California, the California Supreme Court overturned a 110-year sentence on the ground that it was a violation of Graham, and did not give a meaningful opportunity for the juvenile to rehabilitate. There are currently two cases before the Florida Supreme Court, and Florida is sort of famous for its tough sentencing of juveniles. Most of the life without parole cases that were reversed in Graham came from Florida, and the Florida Supreme Court is currently considering 2 cases in which youths received 70 and 90-year sentences, and their attorneys are arguing that this provides no opportunity for reform. Since Miller, there has been, again, a flood of state and federal habeas proceedings addressing the issue of whether Miller is meant to be retroactive and to apply to offenders in prison who were sentenced long before Miller was decided. There seemed to be agreement that Graham is retroactive, that Graham was a substantive rule of constitutional law excluding a category of offenders from a particular sentence. So that hasn't been so controversial. But with Miller, which didn't prohibit life without parole, but simply prohibited the mandatory sentence, there has been a lot of different views among state and federal courts as to whether it's a procedural rule and hence not retroactive, or a substantive rule of constitutional law and is retroactive. And one court has even found Miller to establish the rare bird of a watershed rule of criminal procedure, and made it retroactive on that basis. This issue will continue to play out, but there's another issue that is starting to come up in state and federal courts, which is whether the post-Miller response to sentencing juveniles conforms to the Miller requirements. So, for example, recently, as I'm sure you know, Judge Roof, Pennsylvania passed a law establishing a minimum 35-year sentence for 14-year-old defendants convicted of murder, and 35 years for minimum sentence for 15 to 17-year-olds. And so that statute is being challenged on the ground that it doesn't allow for what Miller emphasizes pretty strongly, that there needs to be an opportunity for the court to consider the immaturity of the juvenile offender. And that was the objection to the mandatory sentence of life without parole, that it didn't allow such an opportunity. And so advocates are arguing in this new set of cases that the sentencing regimes that states have devised in response to Miller may not do that either. Now, one state has embraced the spirit of Miller, if you want to call it that. And California has revised its juvenile sentencing statute in response to Graham and Miller, first to provide that all prisoners serving life without parole for sentences that they got as juveniles are entitled to petition for resentencing. And so without being challenged in court in a habeas proceeding, California legislatively has treated Miller as being retroactive. But it also, more recently, has enacted a statute that creates something that they're calling youth parole hearings. And under this statute, which has a long introductory sentence talking about Miller and Graham and the adolescent brain, and then goes on to provide that parole boards are required to consider releasing juvenile criminals who are given long sentences on an expedited basis. And in these special parole hearings, they are to give great weight to the diminished culpability of juvenile offenders, and almost seeming to say almost a resentencing of whether, asking whether the initial sentence was fair, and also to consider how much the prisoner has matured over time. So picking up on the prescription from Graham. And then other states have embraced brain science and taken the message of Graham and Miller to be important in devising their juvenile justice laws, and so there's been quite a lot of resistance, and certainly in Pennsylvania we've seen that. But there's also been in legislative debate and sometimes in statutes a sort of pointing to adolescent brain science and the immature adolescent brain as the reason in the state of Washington, for example, that a statute requiring a mandatory minimum sentence should be repealed. So I want to close, and this came up in Jeff's talk earlier, but I want to close with a kind of cautionary note about the enthusiasm for bringing this knowledge about adolescent brain development into juvenile justice policy, and particularly into judicial proceedings. The emphasis that in Miller and in the post-Miller sentencing discussion on the immaturity of young offenders and the difference between young offenders and adults is almost suggesting an expanded role for evidence about adolescent immaturity and the immaturity of adolescent brains. And this could be both good and bad. It could be good, perhaps, to the extent that courts are informed about general knowledge about adolescent brain development that, as BJ has suggested, is beginning to indicate pretty strongly that adolescent decision-making really is about criminal offending. It really is different from adults, and it would be good for courts to have that general knowledge in sentencing young offenders, but it seems very likely, and in fact it has already happened, that this focus on the importance of youthful immaturity is an invitation to attorneys to bring in brain research evidence to demonstrate that a particular juvenile either does or does not have an immature brain. And so the applying the general knowledge to the individual offenders, it's almost inevitable that this will happen, and it has already begun to happen. But the scientists, as BJ has suggested, would tell you that it is very premature to think that we have anything to say at this point about whether an individual has a mature or an immature brain. It might be that at some point, behavioral and neuroscience data will provide age norms against which a particular youth could be measured, but we're really not at that point yet. And courts to date have rejected this evidence, to my knowledge, and that's a good thing. So, thank you.
Thank you.